Act is a landmark regulation of artificial intelligence. However, it is a mixed bag. While it increases transparency and accountability of AI systems used in risky contexts, such as law enforcement or welfare allocation, it also has far-reaching exemptions and loopholes which can undermine fundamental rights protections. We asked 3 leading civil society advocates to share their insights on how civil society can still use this new law to keep governments and companies to account.
Hi, I'm Ella Jakubowska. I'm the Head of Policy at European Digital Rights, EDRi. The AI Act, the EU's AI Act, has been passed into law officially, but it's far from the end. It's really the opening of the next chapter in this law. What we've seen as we've worked on it for several years is that there are a lot of really big interests who have a stake in this. We've seen the power of commercial actors, industry, security, and governments. But what we've also seen that as civil society and human rights groups, when we've come together, we have had the power to achieve meaningful change. We've made a difference along with our the allied political stakeholders that have been in charge of this. And we've learned that even when things don't go right on this act, there are always further opportunities to challenge it. It is, as I said, it's not the end, but rather the next chapter. So thinking about biometric surveillance specifically, the EU's AI Act has not landed really where we wanted it to be. There are some really quite dangerous loopholes in the prohibitions on various biometric surveillance practices. At the same time, the Act does establish the principle that there are some uses of AI systems, and specifically biometric systems, that are just too harmful to be allowed. And that's a really important precedent, and one that has implications in the EU and across the world. And so when CSOs are wanting to use the AI Act to challenge harmful biometric practices, this in principle prohibition is one thing that's really important. And in EU countries, there are also opportunities to resist attempts to legalize any biometric mass surveillance under the AI Act, because that is left to the discretion of individual countries, and to continue using other legal mechanisms that we have at our disposal, things like the General Data Protection Regulation, which still offer us a really strong way to fight that.
Hi, my name is Caterina Rodelli and I work as EU Policy Analyst at Access Now. There are many ways in which artificial intelligence systems are used in the migration context. However, the AI Act has created a separate regime for when it is migration, asylum, or border management authorities that use AI systems. There are many ways in which the AI Act does so, but you should know 2 main things. First of all, there is no prohibited AI systems when it is used in the migration context. This means that migration authorities can use also the most dangerous AI systems, such as lie detectors or remote biometric identification systems. The second thing you should know is that migration authorities do not need to be transparent when they use high-risk AI systems. They do not need to provide information on the publicly available database, so we will not know what type of system they are using and against whom. Unfortunately, the AI Act, as it is now, does not offer a lot of opportunities to seek for justice for AI-enabled abuses in the migration context. But there are a couple of things we could do. First of all, you should partner up with fundamental rights bodies in your national context. These institutions have the right to seek for more documentation and information on the uses of high-risk systems by migration authorities. Second of all, we should try to start strategic litigation cases on the prohibitions and make sure that the prohibitions apply also in the migration context. During our advocacy work on the AI Act, we created a civil society organization that brought together migrants' rights and digital rights organizations. This is called Protect Not Surveil. The goal of this coalition is to call on European institutions and member states to stop the use of surveillance technologies against migrant people and racialized communities. We keep on working together even beyond the AI Act, because there are many legislation that will be passed to reinforce the surveillance infrastructure at the borders and in the immigration context more broadly. Get in touch if you want to know more. Unfortunately, with the new parliament and the new commission, we will have a lot of work to do. Thank you.
Hello, I'm Nikolett Aszódi and I work as a policy and advocacy manager at AlgorithmWatch. AlgorithmWatch is a non-governmental, non-profit organization based in Berlin and Zurich. The AI Act EU database provides meaningful transparency about what kind of AI systems exist on the EU market that are high risk, and also, very importantly, information about what kind of high-risk AI systems are being used by the public sector. One of the major shortcomings of the EU database is that in the areas of law enforcement, as well as migration, asylum and border control, the existing high-risk AI systems and their deployments will need to be registered in a non-public section of the EU database, preventing the public from knowing what kind of systems are on the market and which are used in these contexts. Another limitation of the EU database is that the private sector is not obliged to register in the EU database when they use a high-risk AI system. Even though the EU database has some limitations and loopholes, the information contained in it can help with holding AI developers and deployers accountable. Civil society could conduct public interest research based on the information that is contained in the database in order to allow the public to understand more about the implication of these systems on fundamental rights, rule of law, and democracy. Providers who derogate from the high-risk classification because their AI system meets certain criteria are still obliged to register in the EU database. Civil society, for instance, could investigate whether those systems are rightfully qualify as non-high-risk AI systems.
During the AI Act negotiations, civil society came together to advocate for the strongest human rights safeguards, and we played a key role in improving the law. Even though the final text of the AI Act leaves a lot to be desired, we also need to come together now to make sure that we can protect people and their rights in practice, especially those most marginalized in our societies. For example, we can use the transparency tools that the AI Act offers, we can work together with journalists and national human rights institutions and equality bodies to uncover what is hidden, and we can demand action from governments and supervisory authorities to address existing loopholes.